Yeah, my lordship, leave to mention the matter, my lord. My lord, can we mention the matter? Lordship is not audible.
Yes. Yes, online mentionings, please.
Yeah, lordship, I was mentioning a matter upon notice. My
Yes.
lord, this pertains to two connected appeals. My lord, by the last order of this honorable court on 26th April, we were directed to file paper books. When the paper books have been filed, my junior is there with the hard copy of the order. This is pertains to Siliguri Jalpaiguri Development Authority versus Seven World. Para
Right.
31 of the order, para 31 of this order gave us liberty to mention for expeditious hearing of the appeals after paper books are filed. The urgency is that, this pertains to an amusement park in Siliguri, where we are running this park from 2006. The lease agreement validity was 10 plus 11 years. Now, in between, the SGD authorities have cancelled the lease, which is the issue which was the issue in the writ. Ultimately, the writ petition was allowed, and the
So
SGD has
Sharma,
now
it's very
filed.
difficult to hear appeals in this circuit. There is particularly too much pressure of bail, so we cannot reach those matters. No use including. Please mention before the next circuit.
But lordship usually keeps a day for civil matters.
Civil matters, yes, Mr. Sharma, but there are other civil matters also. We have to dispose of those. So not in this circuit. I'm sorry.
The tenure of the lease will be expiring, my lord. The extended period will also end in the meantime. That is the urgency, my lord.
Very
If we
let
can
it
take a
appear on the
chance,
list,
or
but we cannot ensure. We cannot assure you that we
yes,
will take it up.
but
Very well.
we will take a chance on any
Very well. Very well. Very well. Let it appear in the list. Yes. The others.
May I be permitted to mention, my lord? Online mentioning, my lord.
Yes.
Item number 412, my lord. The order impugned has been passed, my lord. Justice Sabyasachi Bhattacharya, my lord. This matter may be released.
If the appeal reach the matter, let it be in the list. If it goes out of the list, it's difficulty bringing it in. When we reach the matter, just remind us. Yes.
Mr. May I have your lordship's kind leave to mention a matter, my lord? This is an appeal from an order of 24th of May, where the writ petition has been allowed, but the learned single judge has failed to consider two reliefs. The police is using a certain notice and preventing me from work of development of a property. But I was only praying if we could come back on the 30th, my lord, and I think endorsement is required for the matter to appear on the 30th or on a certain date. But I should not take more than 10 minutes of your lordship's time.
Mr. Banerjee, we cannot fix matters like this because there are too many bail matters. Sorry.
At least could it appear on the 30th? Then I'll take my chance.
No, Mr. Banerjee, no. Yes, Ms. Pandey.
Your Lordship, item number 362, I was praying that if it could be taken up by the next circuit bench, Your Lordship.
When it is called on, Ms. Pandey, let it remain in the list.
Your Lordship, we are appearing online. Nobody is there to attend it physically. That's the problem.
Maybe it is called on at all. Why are you asking for next circuit before it is taken up? 300 something we may not reach even.
Your Lordship.
Anyway, so no mentioning on that. Yes, call on the list,
My
please.
Lord.
Yes.
Lordship, I am for the petition.
Yes, please. What is that?
Lordship, this is a council brief.
Pardon?
At first, this is a council brief given to me yesterday only.
Yes.
Lordship, after going through the brief, I would like to pray mention for petition number 3 only, and not mention for petition number 1 and 2.
All right.
I'm not pressing for petition number 1 and 2, Lordship. That's because
yes,
petition number 3 is the driver of the commercial vehicle.
Right.
Now, Lordship, my argument is upon a very thin line. Lordship, the accused was arrested on 16/8/2023.
Yes.
Charge sheet was filed on 31st January 2024. Till this date, charge has not been framed.
Well, direct expeditiously charges to framed now, but no bail.
Lordship, he's a commercial vehicle driver.
Even then, no. Learned counsel for the petitioner at the time of hearing, restricts the prayer for bail to petitioner number 3, who was the driver of a commercial vehicle. First up, it is submitted that in view of such status of the petitioner number 3, his direct involvement is suspect in the offense. Full stop next para. Moreover, comma, charge sheet has been filed on January 31, 2024, but charges have not been framed as yet. Full stop next para. However, comma, we do not find any mitigating circumstance to enlarge the petitioner number 3 on bail at this stage, comma, particularly in view of the rigors of section 37 of the NDPS Act. Full stop. However, comma, it is expected that the charges shall be framed expeditiously in the matter. Accordingly, CRM NDPS 249 of 2024 is dismissed with the above observations.
Deeply obliged, Lordship.
Next.
My lord, I am for the petitioner.
Yes.
My lord, the contraband was recovered from another 4 accused, not from the petitioner.
Yes.
My lord, on
No. For yes, this is the second day of circuit. This is the second matter. Why are you asking for time? What is the reason for asking for time? Passover, yes. Passover, yes. You are appearing in both. Let it be called on. Passover. 2 is Passover. 3 karo. Passover. 2 and 3 are passed over. Whenever he comes, please inform the petitioners. Yes. Next.
for the petitioner.
Yes.
My lord, in this case, I have 2 folds of humble submission with your lords.
Yes.
Number 1,
Who is appearing for the other side?
maybe Passover, my lord.
Passover. Call karo.
I'm for the petition, Lordship.
Yes.
Lordship, kindly says page 15 of my petition. Lordship, the arrest memo,
Yes.
column 10 is 1, Deepayan Dotto. Now, kindly says page 11, Lordship, last 4 lines. In the meantime, I informed SST Naka checking team of Ethelbury. One is Sabir Ahmed, another is Deepayan Dotto. So Deepayan Dotto is the part of the raiding team and no independent witness. Though it was seized, can you see the date and the time of seizure? 14 hours. That is 2 p.m.
Yes, what do you say? Not prosecution, you say, as a raiding team.
There is judgment, there is no bar. There is no bar.
Where is the question of not vitiating? You are a member of the raiding team, you raid, you sign as witness. You cannot be the witness of your own cause. Then you are the judge of your own cause. You are signing as witness, you are saying, yes, I have done correctly, I have arrested properly. No, no accommodation in bail. Very well. Bring the judgment tomorrow, Passover. Not today only. দিয়ে দিন আচ্ছা আপনার কাছে দিন একবার দেখবো আমি আজকে দিয়ে দেবেন আমি দেখে নেবো ইয়েস কল অন দ্য নেক্সট ইয়েস
Lordship, though yesterday, my lords have taken a view
forget yesterday, today is a new day. What is it?
regarding the charge sheet filed without FSL report. But if my lord allows me 2 minutes time,
Yes.
certain facts were not placed yesterday, which I would like to place before my
Charge sheet filed without FSL by
FSL.
itself may not be a strong ground.
Please
Yes.
allow me.
Yes.
Lordship, in this matter, what was stated by the state on the earlier day, yesterday, that is, the matters were referred to the larger bench of Supreme Court. It is under now purview of the larger bench. Lordship notes that in Ritu Chabaria's judgment, when This honorable
Larger bench on this point.
On
That's
this point.
yes.
Ritu Chaparia judgment, the apex court granted bail, saying that charge sheet filed without FSL is incomplete charge sheet and bail was granted. Subsequently, it was once again applied before the larger bench and matter now pending before the larger bench. Similar cases have been made a conglomeration of the cases and before the larger bench. Now I am placing the said larger bench judgments.
Larger bench has decided the issue.
Lordship, larger bench has not decided the issue. The latest position is Lordship. This one,
Hani Pansari.
Mohammad Arbaz.
Hani Pansari versus state.
Down. Ekটু down. Yes.
Arbaz,
Down. Just
I'm coming
yes.
to Lordship. Mohammad Arbaz latest judgment, that is.
Give copies. Give copies of
Yes,
it.
it was decided, Lordship. Kindly see, Lordship. This is the same
Okay,
case where all the
Yes.
cases on similar points were taken up. Lordship sees this was decided on 18/7, just 5 days ago. Here, in all the cases, I have all the cases of those SLPs where interim bail was granted to the accused as because, Lordship, if the issue goes in favor of the accused, then his rejection of bail does not make any sense. And in all these cases, Lordship, I'm handing over all the cases.
Yes.
Manpreet Singh
No,
Talwar.
there are cases both ways.
All cases, the interim bail was granted, Lordship.
No, there
On
are
similar
other.
point.
No, but there are cases also where it was not granted.
There were cases, but
So it's both. It operates both ways.
before the larger bench, the SLPs before the larger bench. I'm giving all the cases, Lordship.
Since the issue is before the larger bench, we can take views either way. So satisfy us on law that itself is sufficient with shit. If an issue is pending before a larger bench, that does not go either way. I mean, we can go either way.
Either way.
Yes.
Here, Lordship, policy is the Dibya Vardeva judgment decided on 1st May 2023.
I mean, just because FSL report is not included in the charge sheet, why should it vitiate the process?
To another.
It can very well be filed subsequently by another.
Yes, Lordship, it can be filed. But
When was the charge sheet filed?
Lordship, I'm coming.
In your case?
11/6/2024.
11/6 to 2024.
It's very recent, Mr. Ganguly. At this stage, I mean, they have another chance. I mean, I will give them, we'll give you liberty to come back after a month or something like that if they don't file the charge sheet in the meantime. Don't file the FSL.
Filed 2 judgments also.
There are judgments either way, Mr. Ganguly.
Passed by my lord only.
No, that is not relevant. Who passed the judgment is
No,
not.
coordinate bench has granted bail on this very same point.
When it is before the Supreme Court, we are before wiser heads.
And then
As used by Justice Shobhaji Mukherjee. Yes.
And you see, the wiser bench has granted interim bail in all cases here. Before the
No,
apex court.
you have chosen those cases where it was granted. There are cases where this was not granted also. So we cannot choose like that. So how soon can you file the FSL? Why was it not filed? These people are behind the bars and.
My lord, we have prayed for the CFSL report, my lord.
The charge sheet, there is there in the charge sheet.
Yes.
Definitely, there is a prayer in the charge sheet.
সেটা তো থাকবেই।
We have
Yes.
we have prayed for the CFSL report.
Very well. We'll grant you 1 month's time. Basically, we'll grant them leave to come back after 1 month.
Lordship.
Not grant right now. Learned counsel for the parties, in their usual fairness, point out that the issue as to whether non-filing of FSL with charge sheet vitiates the process and as such entitles an accused to bail. Full stop next para. Upon a considered view of the matter, we find that there are views expressed by the Supreme Court and other benches of different high courts. Either way, full stop next para. Since the issue is pending before the larger bench, under normal circumstances, a liberal view ought to be taken in favor of the accused, keeping in view the principles enshrined in Article 21 of the Constitution of India. Full stop next para. However, in deference to the pendency of the issue before the Supreme Court, at this juncture, we feel it premature to grant bail to the petitioner, since the charge sheet has been filed without the FSL report only on June 11, 2024, and some further time ought to be given to the investigating agency to file the FSL report. Full stop next para. it is expected that such report shall be filed latest within a month from date. Full stop, next para. However, comma, in view of the above observations, we choose not to grant the benefit of bail to the petitioner at this juncture. Full stop. However, comma, leave is granted to the petitioner to apply for bail after a month in the event the FSL report is not filed till then. Full stop. In the light of the above observations, CRM NDPS 266 of 2024 is dismissed.
Grateful, Lordship.
Next.
I'm on behalf of the petitioner.
What is the matter, please?
I renew my prayer for bail, my lord.
When refused last?
I moved this bail application on a totally different footing.
Last refused when? April.
22/4/2024 and extra P1. That's in page number 8.
That is the latest refusal. That is the latest refusal. Yes.
I would like to draw your lordship attention to page number 10. That is the FIR, my lord. For the FIR, my lord,
Yes.
it is alleged, page number 10, that 4 transparent plastic packets weighing 101 gram, which was marked as A, was recovered from Tajibur Rehman, which is the present petitioner, my lord. Thereafter, he says 4 transparent plastic packets, 101 gram, was recovered from another Taribul Islam, that is Exhibit B. And another in point number 3, it says that 11 transparent plastic packets of 101 gram was recovered from another co-accused. So there are Exhibit A, B, and C. So as per law, my lord, the sample was to be drawn from Exhibit A, 2 samples, Exhibit B, 2 samples, Exhibit C, 2 samples, my lord. Now, I would like to draw your lordship attention to page number 13, the certificate of inventory, my lord.
Yes.
Over here, the lordship will find in paragraph number 3, my lord. The said package was weighed by the weighing machine. The said packet containing the contraband item was then kept aside. Thereafter, representative samples of the seized contrabands was drawn out from the said packets and placed inside 2 packets, S1 0.05 grams and level S2 0.5 grams. So only 2 samples were drawn, my lord, which is not as per the procedure of law, my lord. The IO never drew the samples from the mother packets and sent to the CFSL. And in that regard, my lord, I place a judgment of Allahabad High Court.
22nd? আচ্ছা দেখেছি। Yes. Which paragraph in part?
My lord.
Yes.
2.4. This learned senior council has placed relying on the standing order number 1 of 1989, dated 36/1989. In paragraph 2.4, it says, in case of seizure of a single packet container, 1 sample in duplicate shall be drawn. Normally, it is advisable to draw 1 sample from each package container in case of seizure of more than 1 package container.
It is normally an advising.
My lord, I jumped
A bit hyper technical.
3, my lord. Page number 3, my lord.
Yes.
He further placed reliance on a judgment in paragraph number 5. It says, in this case, the conduct of the prosecution of not drawing individual samples from each packet recovered was considered to be violation of standing order aforesaid. Thereafter, I would like to draw your lordship attention to paragraph number 8, that is page number 4. The Allahabad High Court relies on the Apex Court's judgment in Noor Aga versus State of Punjab and Nada. That's in paragraph number 8. The Apex Court has held in para number 123, 124, and 125 that the standing order in dispute and other guidelines issued by the authority having legal sanctions are required to be complied by the subordinate authorities. And in light of that, my lord, the bail was granted in the present case. That is in paragraph number 10, my lord. Paragraph number 10, my lord.
What was the stage of Nooragha?
It was trial was going on, my lord.
Then, I mean, this is hyper-technical. Standing order, we fully agree with you that standing order is a binding guideline.
Sure.
Definitely that.
My lord.
But since the standing order itself says it's advisory,
No,
that
my lord.
cannot vitiate because 4 packets of this is not gaja. This is brown sugar. 4
lord.
packets were recovered from you.
6
This affects society directly. Directly.
6 packets was required to be
4,
drawn,
4, 11. 4, 4, 11. Yes, if there was and might have been an irregularity. We may be right on that. But for that 4 packets recovered from your jeans pant as
4 packets, my lord.
directly from
My
person.
lord, the procedure was that 4 packets, homogeneous mixture was required to be done, and thereafter 2 samples were required to be drawn. My
True.
lord.
True.
Nothing has been done. And if it is not done, the whole case will come to, the validity of the case doesn't arise, my lord. The prosecution will not be able to substantiate the case at the end of the trial, my lord. What's the use of keeping the accused person behind bars?
How long are you in custody?
My lord, 1 year, my lord. My lord, paragraph number 10, if your lordship comes to, paragraph number 10 of the judgment, my lord. Darana.
Para 10 years.
In the present case, there is non-compliance of the procedure of samplings provided under the standing order, which has statutory force, and therefore the applicant may not be held guilty after trial.
What is your antecedent? What do you do?
Huh?
Your client, what does he do? What is your, I mean, what do you do? What is your antecedent? Because that was also considered by the Allahabad High Court.
I have to take instruction, my lord. I don't.
And this is Allahabad is one view, but Delhi High Court view is contrary to that, which has been discussed here also. Allahabad contradicted that view. So Delhi and Punjab and Haryana have held, Delhi, I'm sorry, not Punjab, Delhi High Court has held to the contrary.
But there is
Which was distinguished by Allahabad.
There is a Supreme Court judgment also. Later on, Supreme Court has again affirmed that in the year 2009, in union of
Most of these are in trial from appeals and conviction at those stages. This is a good ground for trial.
My lord, but what's the use, my lord? At the end, they will not be convicted, my lord.
4 packets of brown sugar was recovered from a person. We are a bit strict on that.
That is an allegation, my lord. 4 packets, whether it was required, was
No, we'll at this stage.
my lord, the
No,
most important thing is that, my lord,
Is-
if the sample is not drawn and sent to the CFSL, my lord, whether the case will substantiate, my lord.
This is not a case where the sample was not drawn. Thereafter, the said packet was weighed by the weighing machine.
Yes, my lord.
Said packet containing the contraband item was kept aside. Thereafter, representative samples, we cannot be sure that it was not complied with also.
My lord.
Representative samples of the seized contraband were drawn out
Yes, my lord.
from the said packets. So whether representative samples were drawn out in compliance with the standing order, we are not sure from this much. This is a bit cryptic.
My lord,
We are not sure either way. It
My
might
lord.
have been complied, might not have been complied with.
the 52A, my lord. The 52.
52 is obviously there. Yes.
Yes, my lord. As per that, my lord, there is a procedure of drawing the samples, my lord. That has not been followed in the certificate.
Satisfy us on 52A? Yes. I'll prepare an inventory.
My lord. My lord, the 52A says that 52AC, my lord,
Yes.
allowing to draw representative samples of such drugs and substances in the presence of such magistrate and certifying the correctness of any list of samples so drawn. So the drawal procedure has to be complied by that standing order, my lord. That is very
Not at this stage. Not at this stage.
It's very important because only 2
It is important, but not at this stage. Ash.
My lords, in item number 67 and 67, my lords, kindly hear me for a minute. My lords, item number 66 and 67, I'm for the co-accused in this instant case. My lords may not pass any order without hearing me out, my lord.
Yes, please make your arguments. We are treating you to be a counsel in this matter also, so let make your arguments.
My lords, I have 3-4 grounds. Firstly, I'll take the first ground, my lords.
Yes.
The inventory in this case, my lord.
Right.
The inventory was done after the FSL report was made. FSL report was made.
Inventory was done after the FSL
Yes,
report.
my lords. FSL was done. FSL report is dated 12/10/2023. And inventory was done on 19/10/2023, my lords. FSL on 12/10/2023, inventory on 19/10/2023, my lords.
Are you sure?
Yes, my lords, I'm very sure, my lords. My lords have been annexed in my petition, my lords. There,
What are other grounds? Yes.
yes, my lords. My lords, the independent witnesses, the seizure witnesses, as well as the witness at the time of memo of arrest. Both 3 witnesses have not been made a charge sheet witness at all, my lords. If my lords will take my petition, my lords, item number 67, I mean 66 and 67 both, I'll refer to 66.
So let us take up 67, the other two matters.
67, my lords.
66 and 67 along with this. File give us half a minute. Give our officers half a minute. We are taking up 3 together. Board is 66 and 67 ta dekhiye do, comma diye. You are appearing in both. 66, 67, both are co-accused on similar footing. Yes, we have taken up 66.
My lords will take 67, my lords. I've marked the page numbers for 67.
67, yes.
My
This is CRM NDPS 331.
Yes, my lords.
Yes,
Yes,
which page?
My lord, page number 23 is the inventory certificate.
19th of October.
Yes, ma'am. If
Yes.
you lords will see page number 24, the date is written
Yes, yes, you're right.
19.
90,
My
as
lord,
you said.
FSL report is at page number 25, my lords. 12/10/23, my lords. And the sample was received at the FSL lab at 26/9/23 before the certification, my lords.
Right.
My lords, the rule 13 of the NDPS Act is very clear on this, that the samples have to be first sent for inventory and thereafter for FSL. It cannot be done otherwise, my lords.
That has to be, otherwise
Yes, my lords.
it's putting the cart before the horse.
Entire trial wishes. And my lords, the seizure witness as well as the witness at the memo of arrest, none have been made a charge sheet witness, my lords. And
These,
my lord,
these
yes,
are your points, yes?
yes, ma'am. And as my lords, even like my senior, my learned colleague here, she was mentioning, my lords, one more very, very glaring. Firstly, the sampling were not taken properly, like from each packet.
In isolation, ma'am, we are a bit doubtful on that, whether that, because the language used in the advisory itself is advisory. So standing on an independent footing, that may not vitiate because of the substance involved also. But the other grounds are there also.
My main points are this. Other than that, what has happened, my lords? They've taken 2 samples. Out of the 2 samples, only 1 was sent for FSL, my lords. Which was even thereafter also sent regardless. Only FSL report of 1 sample has been annexed in this.
Does that per se vitiate?
My lords, my other grounds still stand, my lords. I'll just go.
Let us hear the other side, yes.
Certification was done for the
12th FSL inventory 19th. Your officers are complicit. We'll call for the officers. This is absolutely not done. No, if you're corroborating, we need not look into it. I mean, both of you are saying that. Just a second. So,
My lords,
page number.
in conjunction, these 3 afford sufficient ground. এই 3টে ম্যাটার 7, 66, 67 3টে একসঙ্গে দেবে না? No, we'll pass. আচ্ছা, আলাদা করে দাও, এটা প্রথমটাই 70, হ্যাঁ 70. This matter is being taken up in conjunction with CRM বলে আদার দুটো নাম্বার দিয়ে দেবে. CRM such and such and such and such, comma, in view of all the 3 petitioners being co-accused persons with regard to the same offense. First of next para, it transpires upon hearing learned counsel for the parties that there are at least 2 strong and 1 weaker mitigating circumstances. Weaker মানে দুর্বল, hesitate করছো. Weaker mitigating circumstances vitiate the strong rigors of Section 37 of the NDPS Act, colon, niche, Roman 1. The FSL report is dated October 12, 2023, whereas the inventory was done on October 19, 2023, comma, which tantamounts to putting the cart before the horse, which is sufficient to upset the apple cart of the prosecution. Full stop. Roman 2, next para. None of the seizure witnesses form a part of the charge sheet witnesses, comma, which is also another circumstance which casts some doubt on the entire process of arrest and seizure. So next para, Roman 3. Thirdly, comma, learned counsel have relied on a judgment of a learned single judge of the Allahabad High Court in the case of Phul Chand Ali versus Union of India, where the court relied on standing order number SO capital, standing order number 01 of 1989 dated June 13, 1989, in terms of which, in case of seizure of a single packet stroke container, comma, one sample in duplicate shall be drawn, full stop. Normally, comma, it is advisable to draw one sample within bracket in duplicate, bracket closed, from each package stroke container in case of seizure of more than one package stroke container. Full stop. Next para. After giving serious consideration to the legal points involved, comma, we were initially of the opinion that by itself, comma, violation of clause 2.4 of the standing order might not vitiate the process of arrest and seizure standing in isolation, comma, since the expressions used therein are within double inverted normally, double inverted close, and about double inverted advisable, double inverted close, full stop. Next para. However, comma, in conjunction with the other two serious contraventions involved here, as indicated in points Roman I and Roman II above, comma, we are of the considered opinion that the presumption under Section 37 of the NDPS Act cannot be attached to the present case. Full stop. Next para. In such view of the matter, comma, we are inclined to grant bail to the petitioner. Full stop. Next para. Accordingly, CRM, NDPS, এটা 7 একটা করে দেবে, is allowed thereby granting bail to the petitioner on condition of furnishing the bond of rupees 20,000 with two sureties of like amount each, 20,000 because of the brown sugar, 1,000 with two sureties of like amount each, one of whom must be local. Full stop. The petitioner shall not leave the territorial jurisdiction of the trial court throughout the period of trial. Start sheet, what is the stage of the trial? Throughout the period of trial, and shall attend each and every date of trial. To serve that apart, comma, the petitioner shall not commit any offense akin to that for which he has been accused. So thirdly, comma, the petitioner shall not make directly or indirectly any usual. Next para. এর পরে আলাদা অর্ডার করা হচ্ছে 66 যে অর্ডারটা হবে, that will be a copy paste, that will be copy pasted to 67 also. Next, এটা বলো, লেখো. In view of a co-accused in the self-same offense having already been enlarged on bail on detailed reasons in connection with CRM NDPS 7 এর নাম্বারটা দেবে, comma, we intend to extend the same benefit to the present petitioner, comma, since both of them stand on equal footing, comma, invoking the doctrine of parity. Full stop. Next para. Accordingly, CRM such and such is allowed. Same will be copy pasted in 67. Thanks. Same conditions to the satisfaction of which court? NDPS Siliguri. Special court NDPS Siliguri.
Not my objection.
আচ্ছা, প্রথমটা যেটা বললাম, at the outset, comma, serious objection is given to the prayer for bail by the state. এটা তিনটেতেই প্রথম লাইন এটা দিয়ে
Your IO is totally incompetent.
Totally incomplete.
Next.
No doubt.
এগুলো আলাদা আলাদা করে ঢুকিয়ে দিতে হবে একদম লাভ পট
My lord, just now I've received the CD, my lord. I need some time.
tomorrow then
Not filed on 11th of July.
what can I say yes
Passed over. No, I never paid for tax.
next Dakor port
Let it be passed over for some time.
tomorrow let him come in yes tenetটা ready করে রাখো yes
Lordship, I'm for the petition, Lordship.
right
Lordship, column 10 has been signed by constable. This is certificate copy.
how long in custody any other mitigating
Lordship, I'm in custody since 3/11/2023.
yes what do you say
Time of arrest is 1635, and it's fact that is written in the memo of arrest that a constable has signed it. But he is a respectable person also, a constable.
Of the locality.
we don't at all denigrate the respect of the constable but as a raiding party yes he was a part of the raiding party obviously
As per the
Yes. Lordship, Lordship knows better than me that in Taylor versus Taylor, it has been categorically stated that if any act is to be performed in a particular way,
one cannot be the judge of one's own cause
on performing is because the arrest itself is doubtful then. Even any person can be arrested from any place and a raiding team can sign and justify his arrest.
435 what was the place
it was the
Lordship,
place, my lord,
It was
place of arrest is written, my lord.
several in GST more. It's in Jaigaon. Several shops are there, Lordship. In the 435.
constable side course
Caesar list is there. my
হাজার
lord.
হাজার হাজার দোকান আছে
There are independent witnesses in the
That is
Caesar
the
list.
doubt, Lordship. In Caesar list, if the independent witnesses are there, just after the Caesar, the arrest is there.
Maybe at the
signature-
time of
no in the Caesar list there are independent witnesses
next page is the Caesar list.
Lordship, that is the doubt, Lordship. Because if the arrest
Page number
was
6.
if the arrest was made,
so why did you keep the flaw in your arrest memo
What happened, my lord, after in this case, in other cases, first arrest is done, then search and seizure is done. Here, first search and seizure, then memo of arrest. So at the time of search and seizure, there may be witness who have seen the search and seizure. At the time of memo of arrest,
if search and seizure preceded the arrest
my lord,
then all the more it should be the independent witnesses should sign in the memo
at that time they have not.
Lordship, maybe
So that is done. In your case, maybe, my case also maybe. Both are on matter of trial, my lord.
the learned counsel for the petitioner contends that the memo of arrest contains the signature of a constable comma who was apparently a part of the raiding party in the column meant for independent witnesses. Whose sub next para, it is further pointed out that the arrest was effected in a busy crossing at 16:35 hours. Full stop next para. Learned counsel for this state controverts the prayer for bail and submits that in the present case, comma, the search and seizure took place immediately before the arrest, and the seizure list contains signature of independent witnesses, and as such, comma, it cannot be said that the process of arrest was vitiated. Full stop next para. We fail to understand as to why, comma, if the search and seizure took place prior to the arrest, comma, the memo of arrest could not contain any signature of independent witness, which are particularly keeping in view the busy nature of the area where the arrest was effected and the hours at which such arrest was made, comma, we are of the opinion that the process of arrest itself is vitiated due to non-signature of an independent witness. Whose sub next para, learned counsel for the state also seeks to insinuate that a constable may also be treated to be a respectable person. Full stop. We do not have any doubt about the respectability of a constable or for that matter, comma, even the accused. But we are of the opinion that one cannot be the judge of one's own cause. Full stop. As such, comma, there being some doubt in the process of arrest, we are inclined not to attach the rigors of section 37, which do not arise in the present case, of the NDPS Act. Accordingly, CRM NDPS 269 of 2024 is allowed on condition or is similar. Furnishing bond of rupees 10,000 with 2 sureties of like amount, one of whom must be local, to the satisfaction of which court?
Alipurdwar, Lordship.
Special court, NDPS Act, Alipurdwar. বাকিটা সেম সব কোর্টে থাকবে।
What remains with the trial? What remains with the trial?
Lordship. Lordship.
Yes, next. Yes,
My Lord, I am for the petition. on
Right.
this matter. May it please your Lordship, my Lord. My Lord, this is an application for bail. My Lord, primarily, the allegation is that on the basis of a source information, my Lord, that two persons are trafficking narcotics, contraband substances. My Lord, a raiding team was formed, and my Lord, it was they ambushed the present petitioners, and my Lord, they were apprehended with contraband items. Now, my Lord, in the FIR itself, the seizing officer says that while going to the place of occurrence, my Lord, he contacts two persons for making them independent witnesses. Now, my Lord, I'm coming. I'm coming.
can be.
No, my Lord, I'm
What
coming.
else could he do? The poor constable.
My Lord, the case is that these two persons, they reside at a place, my Lord, which is 15 kilometers away from the place of occurrence. The place of occurrence is a busy, crowded marketplace. But in the evening hours, when the raiding team is going to conduct a raid, they call two persons to be independent witnesses, and my Lord takes them with them to the place of occurrence and then conducts the search and seizure.
What is the hour of arrest?
My Lord, it is in the evening hours, my Lord.
What is the location? 5-5. What is the location?
My Lord, it's Milonpolli, Siliguri, my Lord. It's a big, crowded area, my Lord. This is one thing, my Lord. This is one aspect. Second, and the most important aspect is that, my Lord, despite of receiving source information at the police station itself, my Lord, the rigors of section 42 of the act has not been complied with, which is mandatory in nature. My Lord, the Colonel Singh's judgment in 2009, my Lord, the Supreme Court, a constitution bench said that delayed compliance is permissible, but total non-compliance of section 42 is not permissible and vitiates the entire proceedings, my Lord. My Lord, based on the ratio of Colonel Singh.
Why do you say it was not complied with?
My Lord, it is in the FIR itself, my Lord. My Lord will find internal page number 4 of my certified copy. That is the FIR. My Lord, in the middle portion of the page, second paragraph, under this circumstance.
Yes.
Says, under this circumstance, any search warrant or authorization cannot be obtained without affording opportunity for the concealment of evidence or facility for the escape of the offender.
Justified.
So this is, my Lord, this is proviso to section 42(1). It says, if in such circumstances you are not in a position to obtain a search warrant or authorization, then, my Lord, he has to reduce the information in writing, his grounds of belief for not obtaining so, and that has to be sent to his superior officer within 72 hours. And, my Lord, that has to be complied with. The legislature provides them an option that if you are not in a position to obtain search warrant, you have to follow the alternative procedure. So, my Lord, the alternative procedure, if not done, that is an amounts to violation of section 42, and, my Lord, it vitiates the entire proceeding. My Lord, this honorable court as well as the honorable Supreme Court from time to time, my Lord, has passed various judgments and orders, my Lord, thereby granting bail. If my Lord allows me, my Lord, I'll place two coordinate based judgments.
Commercial vehicle.
Here it was not done at all.
No. My Lord, may take Abdul Rakib first.
Lord,
My Lord, may come to page number 3, paragraph number 7.
To the judgment reported in 2021 10 SCC,
Lord,
page
this-
100, authored by Chief Justice of India.
Yes, 2020.
2021.
Yes, which paragraph?
Yes, my lord, para 17, my lord.
Yes.
It says in the present case, the prosecution has submitted that the alleged secret information received by the prosecution was written down with a general diary entry by the special task force, which was subsequent.
Because it's a case of under section 43 of the NDPS Act. That has to be followed. It's a commercial vehicle. Yes.
We'll come to you. Yes. Complete.
Which was subsequently intimated to the superior officer. The relevant documents are part of records. We are, however, of the view that mere a GD entry does not amount to due compliance of section 42(1). The Bombay High Court in Raju Bhavlal Power versus State of Maharashtra bail application number so and so held that an entry taken down in the station diary cannot be treated as information recorded under section 42(1) of the Act. The court relied on Rajaram Kadu versus State of Maharashtra bail application number so and so, also a decision of the Bombay High Court, to hold that an entry in the station diary is not due compliance of section 42(1) of the Act. The second point which merits consideration is whether there has been due compliance of 42(2) of the NDPS Act. The prosecution has relied on the case diary to show that there has been compliance of 42(2) of the Act.
Is 43 circumscribed by 42?
No, 42 is on a different aspect.
This is a public place. This was a public place.
But the vehicle is not a public vehicle. It is a private vehicle, my lord. Bhuta Singh.
It's not a commercial vehicle.
No. My private vehicle, my lord, they also says. In the FIR itself says that one of the co-accused is the owner of the vehicle. My private vehicle, my lord. The second point, which merits consideration, my lord, is whether there has been due compliance of section 42(2) of the Act. The prosecution has relied on the
It was
case
so that case diary is not sufficient. Yes.
Not sufficient. My lord, kindly come to 21. 21 next.
Bhuta Singh, yes.
We also rely on Bhuta Singh to come to the conclusion that non-compliance of 42 is not permissible in law. We are of the view that report under 42(1) must be in terms of a clear recorded statement in writing by the authorized officer under section 42(1) and must not be contained in a document which is closed from public view. Our view is strengthened by the fact that NDPS Act is a special legislation entailing several statutory restrictions against grant of relief. Hence, the obligation cast on the officers must strictly be construed, as also the rights available to an accused under the Act, which must also be given their due weightage. So, my lord, considering this aspect and other judgments of the Honorable Supreme Court, this judgment was passed. Similarly, my lord, Arun Mondo, my lord, I have cited. My lord, Arun Mondo also covers the issue. My lord, may kindly come to paragraph 8, page number 2. Para 8, my lord. It says, we are hence unable to accept the value of the case diary record when the same was not made available to the petitioners. This fact was taken into account in Abdul Rakib versus State of West Bengal. Referred in so and so. We also refer, my lord, one very important, my lord. We also refer to Sarija Banu alias Jantharni alias Janani versus State through the Inspector of Police reported in so and so, where the Supreme Court held that compliance of section 42 is mandatory and is a relevant factor while considering an application for bail. The Supreme Court came to a similar conclusion in the state of Rajasthan versus Jagraj Singh alias Hansa. In Karnal Singh, a full bench of the Supreme Court reiterated that there would be a clear violation of section 42 of the Act, where the police officer had sufficient time to take action but fails to record the information received in writing or send a copy thereof to his superior officer.
So two important things come out from this. One is that they had sufficient time. That is questionable. But even then, this case diary entry would not be sufficient. It's mandatory also. For Let us hear the other side.
Fine.
Yes. No. You people know this better than us.
Huh? Scorpio vehicle in the FIR itself.
Let us see the FIR. Let us see the FIR. What does the FIR? Mahindra Scorpio. If it may be commercial, may not be commercial, but if it is commercial, it should be mentioned. Public place has to be mentioned in the FIR. Has to be indicated at least. It's a public place. Otherwise, section 43 connotation would not come in at all. Presumption is that it's a private vehicle.
72 hours of the in that case,
yes.
22 hours. So
in this case also you have.
He gets 72 hours to inform the superior.
Yes, he did that. No, your checking will not do. It has to be in open. His face is telltale. Whether he has. You should have mentioned that in the FIR also. There has to be some indication for the court to, because you are open to judicial scrutiny in these matters. Case diary. What is the finding of the judgments on case diary? ইনফর্ম করেছে কোথায় বলছে রিজনসটা what has been informed? No, he has to record the grounds for his belief. Recording the incident one. No, বিষয়টা হচ্ছে আসুন এসো। The petitioner contends that the process of search and seizure was vitiated due to non-compliance of section 42 within bracket section 42 of the NDPS Act, whose learned counsel cites two coordinate bench judgment decisions in support of his contention. In the first comma, that of Abdul Rakib versus State of West Bengal reported at 2023 SCC Online Cal 2462, comma, the court inter alia relied on the case of Bhuta Singh versus State of Haryana reported at 2021 SCC Online SC 324 for the proposition that non-compliance of section 42 is not permissible in law. Of that apart, comma, the value of a compliance of section 42 within bracket second proviso as appearing from documents contained in the case diary, comma, which is not open to public scrutiny, comma, was held not to be sufficient compliance of the said provision. Next para, in the case of Arun Mondal versus State, reported at 2024 SCC Online Cal 2729, comma, it was importantly observed, comma, by placing reliance on Sarija Banu alias alias Janani versus State, reported at 2004-12 SCC 466, that compliance of section 42 is mandatory and is a relevant factor while considering an application for bail. In Karnail Singh versus State of Haryana, reported at 2009-8 SCC 539, comma, a full bench of the Supreme Court reiterated that it would be a clear violation of section 42 of the NDPS Act, where the police officer had sufficient time to take action but fails to record the information received in writing or send a copy thereof to the official superior. Next para, learned counsel for the state contends that the arresting personnel reported the matter within the time granted under section 42 within bracket 2 of the NDPS Act, and as such, comma, no mitigating circumstance is available to dispel the presumption under section 37 of the NDPS Act. Next para, the facts of the present case in brief are that comma, upon source information being obtained regarding the alleged offense, comma, the investigating party went to the spot, comma, in the process picking up two independent witnesses. Next para, however, comma, we do not find anything on record to show that the provisions of section 42 within bracket 1, comma, second proviso read in conjunction with subsection 2 of section 42 were complied with. The second proviso referred to above mandates that if an officer has reason to believe that a search warrant or authorization cannot be obtained without affording opportunity for the concealment of evidence or facility for the escape of an offender, comma, he may enter and search such building, comma, conveyance or enclosed space at any time between sunset and sunrise after recording the grounds of his belief. Subsection 2 of section 42, on the other hand, provides that where an officer takes down any information in writing under subsection 1 or records grounds for his belief under the proviso thereto, comma, he shall within 72 hours send a copy thereof to his immediate official superior. Full stop. Next para. Mere intimation to the official superior of the arrest is not sufficient compliance of subsection 2 of section 42. Full stop. In the absence of any such recording and intimation as contemplated in the above provisions, comma, it is mandatory for the raiding party to comply with section 42 with regard to entry, comma, search, comma, seizure and arrest with an warrant or authorization. Full stop. Next para. Another aspect of the matter also needs to be considered. Full stop. The FIR mentions that the vehicle from which the contraband article was recovered is one Mahindra Scorpio having a particular number plate. Full stop. It is nowhere indicated in the entire FIR as to whether such vehicle was a commercial vehicle, comma, particularly in the teeth of the contention of the petitioner that the same was a private vehicle and in no manner a commercial vehicle. Full stop. Next para. In such view of the matter, comma, it cannot be said that the provisions of section 43 regarding seizure and arrest in public place is applicable ex facie in the present case. Full stop. In the absence of the blessings of section 43, comma, section 42 is attracted and it was mandatory to be complied with, which has apparently not been done in the present case. Full stop. Next para. This court is not unaware of the settled position that while deciding a bail, comma, a court is not sitting in a mini trial. Full stop. However, comma, in view of the points which have been argued and controverted by the state, comma, it was necessary to give the above reasonings in order to appreciate whether even the benefit of bail is required to be granted to the petitioner. Full stop. Needless to say, comma, the above findings are tentative and shall not prejudice the rights of either party in the trial in any manner. Full stop. Next para. In view of the above circumstances, comma, we are inclined to grant bail. Accordingly, CRM NDPS 270 of 2024 is allowed granting bail to the petitioner, exactly 10,000 to the satisfaction of Special Court NDPS Siliguri. আর বাকি কন্ডিশন সব থাকবে।
I'm grateful to you.
Thank you. Yes, if both sides are there. Password will Yes, what is your ground?
But without wasting the valuable time of the court, your lordship, this is the two statements of the co-accused persons. These are the two statements wherein the name of this petitioner, both the petitioners are taken by the co-accused who are arrested with contraband. But
he was not arrested with contraband.
Kindly note my objection, my lord.
Yes, you pay your fees. There are two gross mitigating circumstances in the present case to extend the benefit of bail to the petitioner. First, comma, the contraband article was not seized from the petitioner, but from other two co-accused persons. Secondly, comma, the petitioner was apprehended on the basis of statements of the co-accused, which might be taken with a pinch of salt in view of the settled position of law regarding the status of the statements of co-accused persons. Next para. Accordingly, CRM NDPS 252 of 2024 is allowed granting bail to the petitioner.
Condition may be imposed, my lord, in
give us 1 second. Furnishing bond of rupees 5,000. আচ্ছা এটা আমি বলে দিচ্ছি। Yes, charge sheet is yet to be filed. আচ্ছা, I'm passing this order. Subject to furnishing bond of rupees 5,000 with two sureties of like amount each, one of whom must be local. So next para. That apart, comma, the petitioner shall meet the investigating officer once a fortnight and shall not leave the territorial jurisdiction of the prospective trial court throughout the period of trial. Very well. Full stop. Next para. Moreover, that apart, comma, the petitioner shall not make any inducement, threat, or promise directly. Ota. Also, the petitioner shall not commit any offense akin to that for which of which he is accused. Thank you.
Good.
Oh, yes. ওই কোডটা নিয়ে পিটিশনটা পরে দেখে নিয়ে করে নিন। Another co-accused in the same offense?
No, my lord. In this case, my lord, below commercial quantity, 2.70 gram of brown sugar. Your lord.
Since the contraband article seized was below commercial quantity, comma, we are of the opinion that the benefit of bail ought to be extended to the petitioner. Accordingly, CRM NDPS 260 of 2024 is allowed, granting bail subject to furnishing bond of rupees 5,000 with two sureties of like amount, each one of whom must be local. The petitioner shall not leave. What is the stage of the not filed?
Not filed.
So charge
Charge sheet not filed. Charge sheet not.
আচ্ছা next para করে দাও the petitioners shall make themselves available as and when required in order to facilitate the investigation, comma, by the investigating officer, and shall also cooperate in all manner with the investigation. First of next para, that apart, comma, the petitioner shall not leave the territorial jurisdiction of the prospective trial court without leave of the trial court when trial commences. Full stop. Thirdly, the petitioners shall not make any inducement, threat, or promise.
Grateful.
You're not ready? You're ready now? Yes.
Actually, I came late.
Pardon?
I came late, that's why.
No, that's. You have good friends here who ask for time. Yes, Mr. Bhumik, what is the matter?
I'm in custody since 25th September 2023. And the charge sheet was filed on 19th March 2024. As on date, after lapse of 4 months, in spite of having charge sheet, copies were not supplied to us. Number one. Number two, my lord. So, though the charge sheet did not disclose the entire minors, though this is mandatory as per the observation for the Honorable Supreme Court, but so far my knowledge goes, after perusing the case record, I came to know the arrest and recovery was made on 25th September 2023. And the prayer of inventory was made. Inventory was done on 4th October 2023.
4th October is only 9 days.
Delay explanation.
May I permitted to say? And subsequently, the matter was sent to the RFL on 9th October. In this regard, I have to draw your lordship and attention on observation by the coordinate pay, comprising on the motion of the proceeding prisoners. Was a 6 days delay. There was a 6 days delay. On that ground, Honorable Court and Justice tender the petitioner on bail. Can you see?
Yes.
25th July, the arrest was made. 1st July.
We are not of the same view. 6 days delay is not. This is not a ratio laid down. If it was a proposition of law laid down by a coordinate bench, we are bound by that. No, this is not something. This is a bad case, Mr. Bhumi. We have to balance the. Yes.
There's no explanation of the 15 days delay to send the matter.
But copies ought to have been served.
It is fixed. Copies next date. 2nd August is fixed for supply of copy. Date is
I have
fixed.
no criminal antecedent. I am a worker of a medical wholesale distributor. And some.
No, Mr. Bhumi, not in this case. Sorry. The petitioner contends, learned counsel for the petitioner contends that the charge sheet was filed on March 19, 2024, whereas the arrest took place on September 25, 2023. Full stop. Next para. it is submitted that there was a delay in sending the sample for for chemical analysis, which was done only on October 4th, 2023. Next para. Learned Counsel also cites the judgment of an order of a coordinate bench in support of his contention that the delay vitiates the presumption under section 37 of the NDPS Act. Next para, Learned Counsel for the state opposes the prayer for bail and contends that there was sufficient explanation for the delay in sending the matter for chemical analysis. Next para, it is further argued that although the petitioner contends that no copies were supplied, comma, the next date is fixed for supply of such copies. Next para, considering the delay of about 9 days in sending, 9 days for sending. 4th October it was sent. 4th October you said sent. Sorry. The delay of about 9 plus 5. About 14 days. About 14 days in sending the sample for chemical analysis. কি বললাম সেন্টেন্সটা শুরু করলাম? Moreover,
Total process was completed within that.
was explained and is not so large as to vitiate the entire process of arrest and seizure, comma, we are not inclined to grant bail to the petitioner at this stage on the above grounds. Accordingly, CRM NDPS 262 of 2024 is dismissed.
Obliged, Lordship.
This is premature for that, Mr. Bhome. আর আরেকটা লাইন অ্যাড করে দাও, it is না, the state is directed to ensure that
It was fixed for service.
order দেওয়ার মাঝখানে order, please, not during the order, please. Don't discuss during the order. This is absolutely contrary to decorum of court. কি বলছিলাম? It is expected, the state is directed to ensure that copies are duly furnished to the petitioner on the next date fixed. Call on the next matter. Yes. Yes, please.
Lord, I'm for the petition in this matter. Lord, this is an application for bail. Lord, the prosecution case in brief is that, Lord, this petitioner, he traveled from Mumbai International Airport to Bagdogra Airport. Lord, after he landed to Bagdogra Airport at around 2 p.m. On 25th of that month, Lord, he was not getting his bag, his checked-in bag. Lord, he waited for some time and thereafter he contacted the CISF officials. They said that the bag is missing. Wait outside the airport. We will inform you. Lord, thereafter he was waiting there outside the airport from 2 o'clock till 8 in the evening. Lord, he is a resident of nearby district, Uttar Dinajpur, but due to not getting his bag, Lord, he was waiting outside. Lord, at around 10 p.m. at night, Lord, the officials came outside from the airport along with few other officials of the NCB. And Lord, they says that in your bag, we have found some contraband articles and we want to search your bag. Thereafter, Lord, they conducts a search and seizure. Not in presence of him, but conducts a search and seizure and later on says that this is the contraband we have recovered from your bag. And Lord, a search and seizure list was prepared. Lord, two witnesses, CISF officials, Lord, had witnessed the search and seizure in the airport. Lord, there was no independent
At
witness.
10 p.m. in the airport, that may be the situation.
Lord,
I mean,
Lord.
maybe they are the only witnesses.
Lord, yes, I'm coming to that, Lord. What happened thereafter?
Yes.
Lord, he was given a notice under section 67 of the NDPS Act, directing him to come to the Bagdogra police station next day.
Yes.
And Lord, he goes away. Lord, next day, as per the prosecution case, he goes to the Bagdogra police station and thereafter he has been arrested in connection with the present case. Lord, this is the crux of the matter. Lord, in such circumstances, Lordship knows that whenever a person is apprehended on allegation of possessing commercial quantity of narcotics, Lord, no investigating agency will allow him to go away from the clutches of the investigating agency and ask him to come back tomorrow and then he will be arrested. Lord, entire till entire period, my lord, the bag was in the custody of the CISF official.
At 10 p.m. it was not informed to him that the contraband has been found.
At 10 p.m. at night,
It was informed to
it
him.
was informed to him.
The seizure was made then.
Seizure was, the bag was already searched inside. Thereafter, he was told that yes, we have found some contraband articles in your bag. And my lord, from 10 o'clock to 11:45, as per the prosecution, this search and seizure was conducted.
Then you were left alone to go.
Yes. And a 67 notice was given to him that you come tomorrow, meet us. I mean, next day when he goes, he was arrested. That is the prosecution.
Yes, but you cannot take benefit of their charity.
No, my lord.
They should not have let you go at all.
This is not at all a charity, my lord.
Check-in baggage. Check-in luggage. So, I mean, presumption is against you. Section 37 operates. Why not?
My lord, he comes from.
The first case to operate to apply Section 37.
He comes from Mumbai International Airport, my lord. In the international airport, and Mumbai being one of the most busiest international airport has.
No, there is a procedure for putting in the baggage in the check-in luggage.
It was scanned. It was scanned, and thereafter, my lord, it was onboarded. My lord, he comes down to Bagdogra, and when he goes for his check-in baggage, my lord, he was asked to wait outside.
So you say it was scanned in Mumbai when it was not found, but subsequently it never came to his custody, but in the meantime.
Yes, my lord. Yes.
This is your point.
Yes.
Let us hear them. Yes. Yes, Mr. Mujumdar, what is it?
In the interim period, the petitioner is referred a bail before the trial court, which is rejected, and that the client has not been brought to position.
Should have been.
Has dealt with very harshly. That have suppression of material fact will dealt with very harshly. And that is the judgment of that. He is silent about that. Lordship, one thing that we should first consider, check-in luggage when it is scanned by an X-ray, it cannot detect narcotics. Airport security system is put there to find out whether the check-in luggage is containing any arms, explosives, and substances of that kind. My lord, drugs or medicines will not come under scan. That is for that there is a specialized squad with a sleeper dog. It is impossible for the X-ray machine to find out what is there in the packet. If the shape of the packet is not doubtful, it will pass the scanner. No, my lord, out of 230 passengers in that aircraft, what enmity had CISF or NCB with this particular person that they will come? Who planted the nut? The pilot, the co-pilot, the cabin crew. In the middle of the flight, they went into the hold and planted the drug there. Is it a believable story, my lord?
No, from 2 to 8, it was not in his. He did not know what happened.
He did not know.
The bag was not located.
That this particular bag might contain narcotics. The bag was detained. NCB officials were informed. They confirmed that yes, it is narcotics. They not even informed that this is being seized. Search, your bag will be searched and seized. And he was detained in Bagdogra airport. Not some. He was let to go.
Oh, he was not. He did not go home.
No. Everything happened on 25/3.
Oh, he was not let alone to go home.
No.
Acha. Yes, how do you deal with this? What is the reply?
Kindly come to page number 8, my lord, certified copy. That is the memorandum of arrest. Lord, found it. Internal page number 8, my lord.
Yes.
Yes. Lord, first of all, this does not contain any column 10. Secondly, your lordship will find.
This is a new argument you are making in reply.
No, my lord. Since your lordship has not seen it earlier.
Yes.
3, 4, 5, 6. My lord, sixth line. 1, 2, 3.
We have to wait for the independent person.
On 26/3/2024, at about 12:30 hours, at Bagdogra police station, on reasonable belief, prima facie proof that the said goods articles are liable to be confiscation, and thereafter, my lord, he was arrested on 26th March 2024 at 12:30 hours. So, my lord, why he was not arrested on that day when the search and seizure was 12-13 hours before? The search and seizure, the bag was not searched in his presence, my lord. He was only informed that we have found some contraband in your bag. My lord, no gazetted officer was called for witnessing the search and seizure. CISF officials were there. The memo of arrest shows that the arrest has effected somewhere else at a different time.
Search cum seizure list is more elaborate
My lord, they have just put down
and
the
is very specific. Very specific. Your internal page 4 onwards, 4 to 7.
Yes.
These are very, very specific.
My lord, page number 5 is the search cum seizure list.
Right.
Yes.
5 to 7.
Yes, before
I
remarks.
said 4. No, sorry. 5 to 7.
5
Yes.
to 7. Before remarks, Lordship will find search started at 20 to 30 hours
Yes,
on
yes.
25th March 2024 and completed at 23:45 hours on 25th March 2024. So on 25th night from 10:30 to 11:45, my lord, the search and seizure was completed as per them only. And my lord, the arrest, when the arrest was effected, the arrest was effected next day at 12:30 hours. My lord, the search was done in his absence. Lord, from the entire circumstances, Lordship, and ascertain, my lord, under how, my lord, it has been done. My lord, in this regard, my lord, I'd like to rely on a
11:45 hours it was. Yes, you're relying on a judge.
Lord, just to show that the apprehension and arrest and the search and seizure were done at a different place. But page number 2. Page number 2. Though it is not a ratio, my lord.
That yes, this is not a ratio, and it may happen case to case. It differs. The factual circumstances have to be considered. No, what do I do? Where do we get that you were released to go home? I mean,
My lord,
we don't find that.
no, because the
They might have
arrest,
been there in the premises itself.
because the arrest was, Lordship will find,
Arrest is 26th of March.
12:30 hours. 12:30 hours. And my lord will find page number 4, the FIR last part.
Yes, in the next day noon you were arrested.
Next day I was arrested. My lord, kindly see page number 4, FIR last part, paragraph 7. Para 7, my lord.
Yes, para 7.
Says that thereafter MD Shamim was issued notice under section 67 of the NDPS Act 1985 and was asked to appear at Bagdogra police station for recording of his voluntary statement.
From the airport you might have been asked to appear there.
Now, Lordship, kindly appreciate this thing.
Hmm.
Lord, if I have been apprehended with commercial quantity of contraband, Lord, how could this happen, Lord, that I have been asked to appear at a different place? Why?
Why was the arrest affected, Mr. Mujumdar? There is our doubt is only on this. The rest of it is all right.
So inmates of the family of the accused was informed. They came in their presence, the accused arrested. Nowhere we get that he was allowed to go free, roam free. A person charged with contraband articles of commercial quantity, if he gets the chance to walk out, he will meekly come back to the police station, knowing that he will be arrested.
No, because that shows that he was innocent. That is what he's saying. The very fact that he came on your call shows that he's innocent. Anyway, we'll
If written in a format that he was asked to appear, that what is always used, that doesn't mean that he was free. He was not kept under.
we are refusing in this case.
My lord, kindly consider the circumstances, my lord, under which I have been arrested.
And
My lord, I come from Mumbai, my lord. My lord, just 30
Lord Counsel for the petitioner submits that the petitioner came from Mumbai on an aircraft, full stop. Although at the time of the luggage of the petitioner being scrutinized at the Mumbai airport, no apprehension was expressed, and the petitioner was permitted to undertake the journey to Bagdogra, when the petitioner arrived at the Bagdogra airport, he was made to wait from 2 p.m. to 8 p.m. on the pretext that his luggage was not being available. To stop. Subsequently, he was intimated that the luggage apparently contained contraband articles. To stop. At 10 p.m., the seizure was effected in the airport. So it is pointed out that there was no independent witness signing the seizure list. So next para. It is contended that it was rather surprising that the petitioner was let free even after such seizure and was called to the Bagdogra police station the next day, when the arrest was effected. First up, it is also argued that throughout the period, the luggage was beyond the control of the petitioner and as such casts doubt in the entire process of arrest and seizure. First up, next para. You're the public prosecutor. Deputy Solicitor, I'm sorry. Every time I'm sorry for that. Learned Deputy Solicitor General contends, while appearing on behalf of the respondent, that the X-ray machines and other gadgets used under normal circumstances for scrutinizing check-in luggage is not equipped sufficiently to detect the presence of contraband articles or narcotics in the luggage. Next para. As such, whenever the luggage reached the Bagdogra airport, it was suspected that there was contraband articles therein, for which due searches were effected and the seizure took place at around 10 p.m. It is further argued that merely because the petitioner was called to the Bagdogra police station does not per se show that he was let alone, go scot-free in the interregnum. Next para. Further, it is argued that the strong presumption of Section 37 of the NDPS Act is squarely applicable to the present case. Next para. Upon careful consideration of the rival contentions of the parties, this court is of the opinion that no gross irregularity or violation of any legal mandate has been made out by the petitioner to cast sufficient doubt in the process of search and seizure in the particular circumstances of this case, so as to enlarge the petitioner on bail at this stage. Thus, the rigors of Section 37 of the NDPS Act are applicable. Accordingly, CRM NDPS 271 of 2024 is dismissed.
I'm grateful.
Sorry. এটা ফেলে দিন, এটা ওনাকে চলে গেছে, রেখে দাও। Next. Yes, Sabudha, what is the matter?
This case, petitioner is custody about 493 near about 1 year 4 months. Recovery 26 bottle of cough syrup.
What is the stage of the trial?
Charge sheet was submitted on 27th August 2023. Till today, my lord, charge not framed.
Charge not framed?
Yes, my lord. I am relying on this court, my lord, to decision of this our court, my lord.
Yes, there are several judgments of the Supreme Court. Here, what do you say?
Charge sheet is not done. It is January 2024 by the court. And right now, stage is 29/8/24 for date is fixed for hearing and production.
Charges have not been framed for more than a year.
My lord.
No, we will grant bail. The petitioner contends that Although charge sheet was filed as long back as on August 27, 2022, comma, the charges have not yet been framed. So the petition is already in custody for about oh, 1 minute, 1 minute. Order to get. Yes, what are you saying, Mr.?
7 August 23, my lord, I say, my lord. I am in custody about 1 year, my lord, 4 months, my lord. 493 days, my lord. I submitted, my lord.
Charge sheet is dated 27th of August 2023. You said 22.
My lord, 23. I say, my lord, I am in custody about 1 year.
Not 18 something, 23, but 27th August.
7 August.
Yes. নতুন করে শুরু করো। The petitioner contends that the petitioner is in custody for about 493 days. Stop. Charge sheet was filed on August 27, 2023, but till date, charges have not been framed. Full stop. The petitioner relies on coordinate bench orders granting bail, comma, relying on the judgment of Rabi Prakash versus State of Odisha, reported at 2023 SCC Online SC 1109, where delay was treated to be a ground for grant of bail. Full stop. Since the trial has not yet commenced and in view of the inordinate delay in framing of charges, comma, we are inclined to grant bail to the petitioner, comma, since the period of custody itself as an under trial mitigates the rigors of Section 37 of the NDPS Act as per the consistent view of the Supreme Court. Full stop. Accordingly, CRM NDPS 272 of 2024 is allowed, granting bail to the petitioner on condition of furnishing bond of rupees 10,000 with 2 sureties of like amount each, one of whom must be local, to the satisfaction of the special court NDPS at Siliguri. Case of the petitioner shall not leave the territorial jurisdiction of the trial court throughout the period of trial and shall attend on each and every date of trial. Case of moreover, comma, the petitioner shall not make any inducement, threat or promise. Thank you. একটা লাইন অ্যাড করে নিও যেখানে accordingly is allowed এর আগে learned counsel for the state opposes the prayer for bail. কোথাও একটা ঢুকিয়ে দিও সুটেবল জায়গা। Yes.
Also my renewal of my prayer for bail, my lord.
When refused?
Prayer was refused for 22nd February 2024. My lord, page 8 of my rejection.
Quite recently, what happened after that? Any change of circumstance?
15 days, my lord, near about 2 years, my lord. Till today, no witness was examined, my lord. Charge sheet was submitted, my lord, 31st January 2023. Thereafter, my lord, supplementary charge sheet submitted on 6th March 2023, my lord. Charge sheet submitted without chemical examination report on 13th January 2023.
You are in custody for?
Near about 2 years, my lord, 715 days. Till today, no proceedings was examined, my lord.
Yes, what do you say? No prosecution witness as yet examined 715 days.
25/9/2024 for evidence because the supplementary charge sheet was submitted and due to that this was long back, my lord, on 6th March 2023, my lord. Long back. There is no progress in trial, my lord. There is near about 2 years, my lord, there is several decisions.
March 6, 2023, it was filed. Supplementary. In the present case, comma, we find that bail, similar prayer for bail was refused on February 22, 2024, full stop. However, comma, we find that the period of custody, which is now pleaded by the petitioner, was not specifically considered in the said judgment, full stop. In any event, comma, the prior refusal of bail per se does not operate as res judicata in a criminal matter. Full stop. Next para. The petition is already in custody for 715 days. Full stop. No prosecution witness has yet been examined, although it is contended by the prosecution that the trial, the next date of trial has been fixed when?
25th September 2020.
On September 25, 2024. Full stop. We find from the records and the submissions of parties that the charge sheet was filed on July 31, 2023, and supplementary charge sheet was filed on March 6, 2023. Full stop. Next para. It is well settled that considerable delay in prosecution is itself a ground for grant of bail, comma, particularly keeping in view that the petitioner was not at fault for such delay and has already been in custody for a prolonged period of 715 days as an under trial. Full stop. Accordingly, comma, in deference to the fundamental right enshrined in Article 21 of the Constitution of India, comma, we are of the opinion that the prolonged period of custody justifies grant of bail to the petitioner. Hence, CRM NDPS 273 of 2024 is allowed, granting bail to the petitioner, usual conditions. আচ্ছা, next, hence এর আগে, hence we feel that it is কি justifies যেখানে বললাম justifies সেন্টেন্সটা শেষের জায়গায় একটা কমা দিয়ে despite the objection to the bail raised by the state. We'll come back in 5 minutes. Gazette of zero. Yes,
Item 14 only.
not today.
Not I for the picture.
16th bar for yes. What is the violation?
Yes, my lord. If your lordship, my lord, kindly take the rules of my lord. Rule 11, my lord.
Yes.
11, my lord. Quantity to be drawn for sampling.
Right.
Well, except in cases of opium, ganja, and choro, bracket, and where a quantity of not less than 24 grams shall be drawn for each sample. In all other cases, not less than 5 grams shall be drawn for each sample, and the quantity shall be taken for the rule 11, madam. One thing, madam. Another thing, madam, rule 14, madam. Rule 14, madam. Expedient, the laboratory shall submit its report to the court of magistrate with a copy to the investigating officer within 15 days from the date of the sample, madam. This is rule, madam. Kindly, if your lordship take the chemical examination report, madam. Certified copy, madam. My lord. Last thing, madam. What of sample, madam?
Yes.
What of sample with plastic, madam? 4 grams, madam. What of sample with plastic, madam? What of sample with envelope 22 grams, madam? The rule says not less than 5 grams.
No, rule ta
Okay, take this point in trial. Not so much, not so high, not on a
52 FD Act.
Right.
This rule was made. If your lordship can take the
yes.
rule, first of the preliminary and the
Yeah, it starts with that.
start with this objective. In consonance with the rule was made in consonance with Monolal Jalpan and all these things for this rule comparing. If your lordship takes this thing for a period of testing, for a period of testing, or it was said date was received on 28 November 2023, top laboratory number and date of receipt, and period of testing 24 April 2024. In the month of November, in the month of April 2024, these are all violations.
November, what we, acha.
Yes,
Date.
yes, top.
The top date is 24th of April.
Period of testing,
Period of testing.
24th of April 2024.
Same date.
No, date of receipt,
Date of receipt of the sample is 28th November.
28th November.
5 months after that.
This 4 my lord, I rely to judgment upon after 5 months.
Yes.
Can you see the judgment? One is 5 grams. It's a mandatory sample to be taken. 4 grams. And the later preparation of report. All periods, my lords, will keep this. There is a mandatory violation of trying sample.
Much later than 15 days.
Yes, my lord. And period of the last paragraph also, my lord. Period sample report was prepared also less. And there is a delay of sending of the sample also, my lord. And there is other thing also, my lord. Drawing of sample 5 gram must be, I say in rule 11, my lord. There is violation of rule 11. And period of testing within expeditious testing, my lord. Expeditious disposal, expeditious visit, and expeditious testing, my lord. In consonance with 52A, my lord. That is serious violation.
Yes. What do you say?
Now, my lord,
the case was registered on 17th of November 2023. Lord, immediately a prayer for certification was done. Lord, the certification was completed on 21st of November. That is after 3 days of seizure. Lord, and thereafter on 24th. Wait. Lord, after 3 days of seizure, on 21st of November, the inventory was done. Lord, after the inventory was done, Lord, the exhibits were handed over to the investigating officer, and on 24th of November, it was sent to the CFSL lab. That is, Lord, after 6 days almost. After 6 days of seizure, it was sent to the lab. Lord, the laboratory, after receiving the same, Lord, has given has sent this report on 24th of March, 24th of April. So it was with the laboratory, Milord, and within the statutory period, Milord, the this report has been filed before the learned trial court. Milord, another contention.
Not within statutory period. The chemical laboratory shall submit its report to the magistrate within 15 days. And here it was 5 months, 4 months.
Milord knows.
5 months actually.
Yes, Milord, that is the rules. But Milord knows.
5 months
Milord,
instead of 15 days.
I'll try
If
to-
it was a few days, we could have understood.
Milord, after it, the statutory period of the NDPS Act for investigation is 6 months normally, Milord, and usually within that period, Milord, it is expected that the charge sheet would be filed along with the CFSL report. Now, Milord, unless the CFSL report comes from the laboratory, Milord, the investigating agency cannot file a report to that effect. And moreover, Lordship knows that the CFSL laboratories are very limited in numbers in the country, Milord, and moreover, now with the enactment of the new criminal laws, Milord, the forensic part has been incorporated in the general law itself.
That was after this.
Yes,
That was after this.
But there is immense pressure on the forensic laboratories, Milord. So, unless I receive, being the investigating agency, Milord, the report from the laboratory, Milord, I have nothing to do. But within the statutory period, I have received it. I have filed the charge sheet along with the CFSL report. So, Milord, there is no infraction on the part of the investigating agency in the present case. And, Milord, since it has been filed within the statutory period, Milord, there is no infraction on the part of the police or on the part of the investigating agency. Milord, there are ample judgments of the Honorable Supreme Court that if within the statutory period it is filed, Milord, there is no infraction and no lacuna on the part of.
How do you deal with Rule 14? It's mandatory. Shall submit its report. Rule 14 of this NDPS rules. Expeditious test. No, take this. Take our copy. Do you have an extra copy? Give it to him. Please see Rule 14. Still, we say we could have understood if it was 15 days more, suppose 1 month, but 5 months.
My lord, there is a proviso too.
Yes.
That says, my lord, provided that where quantitative analysis requires longer time,
yes,
the results of the qualitative test shall be dispatched to the court of magistrate with a copy to the investigating officer within the said time.
So that goes against you.
On the original copy, yes, that is true, my lord. But there are judgments.
Saw the proviso.
My lord, there are judgments to that effect. I can
to what effect?
To this effect that if the statute within the statutory period of investigation, if the CFSL report is filed along in the charge sheet, there is no lacuna on the part of the investigating agency. My lord, the Supreme Court says.
No, may not be investigative agency's fault, but this is sufficient. Yes.
My lord, in view of this, my lord, if this
no, we'll record that in this particular case, we find a delay of 5 months, which is exorbitant. We'll specifically state that. Otherwise, in every case where there is a few days delay, it cannot be a vitiating factor. You are right. Very right.
Open floodgates, my lord.
No, we'll check the floodgate in our order itself. We are conscious of that. You are right. Learned counsel for the petitioner argues that in terms of the NDPS within bracket seizure, storage, sampling and disposal bracket close rules, 2022, it is mandatory that in cases other than opium, ganja and chorus within bracket hashish bracket closed, not less than 5 grams samples are to be drawn for each sample, and the same quantity is to be taken for the duplicate sample. Push up. In the present case, as evident from the chemical analysis report, the weight of sample with plastic was 4 gram. Pushed up. Next para, it is further submitted that Rule 14 of the said rules provides that the chemical laboratory shall submit its report to the Court of Magistrate with a copy of the investigating officer, with a copy to the investigating officer within 15 days from the date of receipt of the sample, which have in the present case, comma, the delay occasioned from receipt of the sample and to TO2 giving the report was 5 months. Which of next parallel counsel for the respondents opposes the prayer for bail and submits that it is well settled that if the FSL report is filed with the charge sheet, comma, no suspicion can be cast on the process of search and seizure. Which of that apart, comma, the investigating agency obtained a certificate of inventory on November 21, 2024, that is 2023, comma, that is soon after the seizure, and sent the report for sampling on November 28, 2023, comma, as such, comma, there could not be any delay on the part of the prosecution. Which of next para, a careful scrutiny of Rule 11 of the 2022 rules indicates that the sample to be drawn from each, the amount to be, the quantity to be drawn from each of the samples has to be not less than 5 grams. Pushed up in the present case, comma, the sample drawn with the plastic packet was 4 grams. Pushed up next para, however, comma, we are of the opinion that such infraction of the rule, comma, if any, comma, is by itself not sufficient to justify grant of bail. Which of next para, the next component of challenge is that although Rule 14 mandates that the report is to be submitted within 15 days from receipt, comma, in the present case, comma, delay was more than 5 months. Which of next para, the proviso to Rule 14 also indicates that where quantitative analysis requires longer time than 15 days, comma, the result of the qualitative test shall be dispatched to the court of magistrate with a copy to investigating officer within the said time limit on the original copy of the test memo. And in the next 15 days, the result of quantitative test shall also be indicated on the duplicate test memo and sent to the court of magistrate with a copy to the investigating officer. Which of thus, comma, the outer limit for indicating the quantitative test result is 30 days from the date of receipt from the sample, which has been grossly flouted in the present case. Pushed up, the laboratory which was entrusted with the job of chemical analysis took 4 months, even beyond the outer limit, for indicating the quantitative test report, and there is nothing on record to show that the qualitative test result was intimated to the magistrate within the time limit of 15 days. Which of next para, although the investigating agency itself might not be responsible for the delay, comma, even if the laboratory was responsible for the same, comma, since the entire process was delayed by over 4 months, comma, grossly contravening the provisions of the 2022 rules, comma, we are of the opinion that the presumption under section 37 cannot be attached to the present case. Which of next para, however, comma, we are also of the further view that mere infraction of the rules by a few days might not be sufficient to justify vitiating the process. Full stop. In the circumstances of this particular case, comma, since the delay was about 5 months, comma, we are inclined to grant benefit of doubt to the petitioner in the circumstances of the case. Full stop. Next para. Accordingly, CRM such and such, CRM NDPS 275 of 2024 is allowed, granting bail to the petitioner on condition that the petitioner furnishes bond of rupees 10,000 with 2 sureties of like amount each, one of whom must be local to the satisfaction of the special court NDPS Siliguri. Full stop. বাকিগুলো একই থাকবে। এই কপি একটা ফটোকপি করে এখানে দিয়ে রেখো, তো এই বইয়ের সঙ্গে দিয়ে রেখো, এতেও থাকবে, আর ফটোকপি এখানে রেখে Not. Yes. Yes.
Not pass over, Lordship.
Password. I will make it not today then. Instead of the uncertainty, not today. Yes. Yes. When was it refused last?
Kindly come to the order with preparing a floor. Page 10 of my application.
Yes. Expected to be completed in 6 months. 6 months is not yet over.
They have not even framed charge. So there is no possibility of them completing this trial in the next few months.
Why have charges not been framed?
Lordship, it will be completed, Lordship. 6 months is not yet over, Lordship.
Lordship,
No, 6 months is not yet over, but the prospects are very gloomy.
Lordship, 20 witnesses.
17 it was recorded.
Lordship, 20.
19. Two independent?
Lordship, I have annexed the charge sheet.
No, we'll grant you leave to renew your prayer after 6 months. We won't interfere in this.
Lordship, even the co-accused, Lordship, they are also on bail, Lordship. Both the co-accused persons. One is
Yes, but in view of this rejection, I mean,
Lordship, but then Lordship,
co-accused were granted bail after this order. Give us the dates.
27/20/23. Prior to this
Lordship, prior to this order, Lordship.
Then it was within the knowledge of.
Lordship, even the principal accused, Lordship, the kingpin, Lordship, he is an anticipatory bail, Lordship.
Yes, but all these facts were available before the division bench. And otherwise, we would not have said so. But it has given them 6 months to conclude the. 6 months will be over in September. There's quite some time left.
6 months prior, Lordship, they not even framed charges, Lordship.
No, come back after 6 months.
Charge sheet was submitted in 2023, Lordship, August 2023, Lordship. Lordship, there is no recovery from him also.
Even then.
Lordship, there's been a considerable period of time. Lordship,
No, you can withdraw. We can give you liberty to withdraw this. Or we can record it that we are giving you liberty to withdraw with liberty.
Lordship, then kindly place us before the next circuit, Lordship.
On the prayer of the petitioner, let the matter stand adjourned till the next circuit.
Lordship, I'm for the state, Lordship. Lordship, I'm praying for 1 day accommodation, Lordship.
State is not ready in these matters. I mean, not even 25 matters we have called. Why not? Come back tomorrow. Not today. Next step.
Lordship, CD has yet to be received, Lordship.
Not today. Not today.
I'm for this.
Yes. None appears to move. Yes.
I'm for the traditional method. Hello, in this matter, the report was filed after, the seizure was made on 16th of March 2023.
Yes.
Supplementary charge sheet was filed on with the state social report on 11th of June 2024. More than 1 year. And my lord,
The report was dated 14th of December 2023. There is a long gap, my lord, between the seizure and the report and the submission of the supplementary charges. Moreover, my lord.
But it has now been submitted.
That 1 year, 4 months have passed, my lord. Charge has not been said, my lord.
You're in custody for 1 year, 4 months.
My lord, this is not the case.
Different case.
Next one.
Too many matters. Achha, your name is Kumar Shantanu. Shantanu is your title.
Second case.
It's like Kumar Shanu sort of thing. So you are Shantanu Kumar. Where?
My title is Roy, but my father name.
Achha, all right. Please move.
My lord, the petitioner in custody since 8th of January 2023, more than 1 year, 7 months, my lord. There is a delay in sending of the samples, my lord. The samples was received on 17th of January 2023. Seizure was made on 8th of January 2023. Sample received on 17th of January 2023, and report was filed on 1st of June 2023.
1st of June.
21st. 5 months delay, my lord, which directly violates Rule 14 of the NDPS Rules 2022. Total witnesses are, my lord, 14. Charge has not been set till already 1 year, 7 months in custody.
Yes, what this?
He by profession is a coolie working in the Siliguri bus stand, my lord. He works as a coolie. The fact is that a passenger handed over some articles to carry. When the passenger saw the raiding team coming, he fled and they were caught. This is the fact.
Yes, what this?
My lord, charge sheet filed on 25th 6 2023. One accused person is still absconding. So next date is fixed on 25th. This
That
month.
accused person was the person whose luggage he was carrying.
Yes, my lord.
See, he's a poor porter. I mean, he was with the luggage and he was caught.
My lord, they were together, my lord. They were together at that.
If the porter is not with you when your luggage is being carried, then the porter will be hauled up for that. Porter, weird. The petitioner seeks bail on several grounds. First, it is contended that the petitioner was a porter within bracket coolie bracket closed in a railway station and was carrying the luggage of the persons of other persons, who are also co-accused. Next para. It is further submitted that the petitioner is already in custody for about 1 year, 7 months. There was a delay in receipt of the.
My lord, that is explained in there.
Acha, I will record the submission. We'll say that there was a delay in receipt of the chemical analysis report as well. Next para, it is further argued that there are 14 named witnesses, but no charges have yet been framed, making it uncertain as to when the trial will be concluded. Next para, learned counsel for the state opposes the prayer for bail and submits that there is sufficient explanation on record for the delay in obtaining the chemical analysis report. Next para. However, we find that there are 14 named prosecution witnesses, whereas even the charges have not been framed, despite the petitioner being already behind the bars as an under trial for about 1 year and 7 months. That apart, there is sufficient prima facie doubt as to the involvement of the petitioner, who was a mere porter and earns his livelihood by carrying luggage of others. Next para, in view of such mitigating circumstance regarding the involvement of the petitioner, since we are unsure of the involvement of the petitioner, and as there is prima facie doubt as to whether the petitioner shall commit such offence if enlarged on bail, comma, we are inclined to hold that the petitioner falls within the mitigating circumstances under section 37 within bracket 2 of the NDPS Act. Accordingly, CRM NDPS 285 of 2024 is allowed, granting bail to the petitioner. বাকি সব সেম থাকবে to the satisfaction আচ্ছা
objection
আচ্ছা accordingly আগে একটা thus comma despite the objection of the state comma we are inclined to grant bail to serve. Accordingly, CRM NDPS 285 of 2024 is allowed, granting bail to the petitioner on condition that the petitioner furnishes a bond of rupees 2000 with 2 sureties of like amount each, one of whom must be local, to the satisfaction of the what is the
Learned Judge Special Court, Jalpaiguri.
no, just special court to the satisfaction of special court NDPS Act Jalpaiguri. Push up বাকিগুলো একই থাকবে.
My lord, they belongs to Bihar.
Bihar. No, they will not leave the territorial jurisdiction of them. The rest of the riders remain the same, will not leave the territorial jurisdiction. Jalpaiguri Siliguri হয়ে গেছে. But you will not leave the territorial jurisdiction.
I am for the petition.
Most of our porters are hail from Bihar probably. Many of our porters. So that applies. Yes. Yes, what did you do?
My lord, I am behind bar since 1 year, 4 months, my lord. The seizure was made on 16th of March 2023. It was received on 24th of March 2023. Report was furnished on 14th of December 2023. And charge sheet was filed on supplementary charge sheet was filed on 16th of June 2024. There is no explanation regarding this delay.
Please give us a date second for 16th of March Caesar, 24th of March 23. What happened? Sample was sent, received.
Thereafter, my lord, report was furnished on 14th of December 2023.
After 9 months?
Yes, my lord. And thereafter, my lord, after 6 months, they have filed the supplementary charge sheet with the CFSL report. And there is no explanation regarding this delay. This is the certified.
Yes, what do you say? Why so much delay? 9 months in furnishing the report and 6 months after that you file with a supplementary.
They had given a prayer in the charge sheet, my lord, for
We can understand, but after 6 months, why was it filed after 6 months, even from the furnishing of the report?
My lord, I would like to show my lord from page number 50 of their annexure, my lord.
Their annexure?
Yes, my lord. Their annexure, my lord.
Page 50, yes.
Page 50, my lord, series of rejections were there, my lord. They had already raised this issue on the earlier occasions also, my lord. But it was not confirmed.
Show us from anywhere.
Page number 50, my lord, dated, my lord, from 28/11/2023, my lord. And next page 50, 51, 52, my lord. These points were not agitated, but they had filed the bail application, my lord. And it was
The bail application was withdrawn, my lord, because if my lord see, come to page 36 of my petition. 19/6/2024, the bail order, the application was withdrawn. When they submitted submitted that charge sheet has supplementary charge sheet has been filed, I asked the honorable court that allow me liberty to go through the supplementary charge sheet. That's why I withdrawn.
Yes, yes. Vishwajit. The petitioner contends that the seizure was effected on March 16, 2023, and the sample was received on March 24, 2023. Full stop. However, comma, after about 9 months thereafter, comma, the report was furnished on December 14, 2023. Full stop. All the more, comma, all the more, comma, the FSL report was filed with the supplementary charge sheet in June 2023, that is 6 months thereafter. Push up, it is submitted that the said span of delays vitiates the presumption under section 37 of the NDPS Act. Who's the next para? Learned counsel for the state opposes the prayer for bail and points out that on several previous occasions, the petitioner failed to obtain bail. Full stop. On a careful consideration, we find from the records that at least or on 4/5 occasions, either the petitioner withdrew the prayer for bail or the same was dismissed as not pressed. Full stop. Next para. Substantial rejection of the bail prayer of the petitioner took place on
17/5/2024.
On May 17, 2024, lastly. Where is that? Which page?
It is at page number, my lord, 52, my lord. Sorry, my lord, running page number 53. 53, my lord, 53.
Full stop. Next para. However, from the said order of rejection, we find only reference to the narcotics being above commercial quantity and cursory reference to section 37 of the NDPS Act. Full stop. However, the delays as pleaded now were not argued before the said bench. Full stop. Next para. We find that there is gross violation of Rule 14 of the NDPS Rules 2022 in view of the report being furnished, chemical analysis report being furnished after about 9 months from receipt of the same, and the same being filed in court after 6 months thereafter. Full stop. Hence, we do not find that there is any further reason to continue the rigors of section 37 to the petitioner. Accordingly, CRM NDPS 286 of 2024 is allowed, granting bail. Usual conditions, 10,000 hobe bondta. To the satisfaction of which court?
Special court under NDPS Act, Jalpaiguri.
Special court NDPS, Jalpaiguri. Thank you. Thank you. So, Laxam, please take this.
Yes, sir.
Oh, sorry. Second. Yes, Mr. Bhoy.
What happened, Milord? There is a sad demise of Mighty, Milord. So there is So there is a resolution in the principal Milord bench from a 10:30, Milord.
Oh.
So that has come little late, Milord. So
you have adopted that?
We are also generally, Milord. This is the generally we adopt. Milord, if in any circumstances we are from the state, if any petitioners they incline to proceed, we do not mind for that. But principally when there is a resolution,
whatever you say, we'll then continue to take up matters. If you say that, if there is an urgent matter, all bills are urgent.
Yes.
And if you want to do the matter, we'll take up matters because that's our job.
Milord, even we cannot say that.
Whatever you say, whatever the bar says.
Because it has been also the same resolution, adopted in the other courts, Milord.
So if you so, then we'll rise. No difficulty on that.
But it is up to the Milord, the learned friends or the petitioners, Milord. It is up to that whether
petitioners, advocates are not an organized body as such. They cannot speak for the others.
Milord, the difficulties is that actually there is now in a form there is no bar association. This is the problem also we face.
You don't have a bar association?
We have a ad hoc bar association, Milord, from the inception. Since of the 19, but generally, Milord, we adopt the
whatever the advocates say. If you want to move the matter, we can call them call on the matters. Then, if we can ascertain, we shall call if some matters. If somebody is present, we'll take up. We'll call for some time. If nobody appears or nobody seeks to move the matter, then we can stop. Whatever you say.
I think, Milord, not.
Then we'll rise. Chalo. Today, it's the
Sure.
Yes.